from the property. Therefore, what is contained in Transfer of Property Act with regard to lease, obligations of lessor, obligations of lessee, and all these things, they constitute what is known as substantive law, because they lay down the substantive rights of parties. What are the rights of parties under the lease agreement? So this is, therefore you have to issue a notice, and similarly, if it is a partition suit or a suit for specific performance also, you should issue a notice. Particularly in suit for specific performance, you have to issue a notice on so and so date you have entered into the agreement of sale. You have received so much balance of consideration. You promised to get the land surveyed or measurements taken, and then arrive at the actual extent, and but you have not done so, or I have come to you with the money but you have not cooperated. Now I am ready to obtain a sale deed. If it is on behalf of the seller, I agreed to sell you land. You have paid so much of advance. Time is the essence of contract. We agreed to pay the balance of sale consideration within 60 days. I gave you notice, you did not respond. You have not obtained sale deed, you have not paid the sale consideration. Therefore, as per so and so clause of the agreement, or otherwise, I am forfeiting the advance. This is the on these lines, you may have to issue a notice in specific performance issues arising out of agreement of sale, or even other agreements also you have to go through the terms and conditions and issue a notice before you file a suit with regard to the obligations to be performed by the defendant under the agreement. And sometimes if it is a case involving, commercial transactions, please verify whether the agreement contains a clause to refer the dispute to arbitration. Because under section 8, please note that 8 of the Arbitration Act, if there is an arbitration clause, the civil suit is not maintainable. That is one thing. So these are all precautions which you have to take when you prepare a case. And then please see that the notice is served. Please elicit the address of the defendant correctly and send the notice by registered post as well as courier, if you think that the party may avoid it. So if reply is received, you also go through the reply and decide whether you need to give a rejoinder. Suppose you issue a notice seeking partition of the family properties, stating that so and so died intestate, and then you receive a reply stating that no, he did not die intestate, it is his self-acquired property, he executed a will, and you are not one of the legatees. As per the will, so and so is entitled to the property. You are not entitled to seek partition. Then you have to issue a rejoinder. Property is joint property for so and so reasons. By the time of the alleged will, the person who was who executed the will was not in a fit state of mind, or whatever it is on the basis of the instructions given by your client. Therefore, depending on the reply, you have to decide whether a rejoinder is necessary. And then you have to decide whether the dispute between the parties can be solved at the notice stage, depending on the exchange of notices, the contents of the notices. And then there is nothing wrong to advise your party to go for a settlement if at all there is scope as per the reply notice, etc. And also depending on the nature of the case, nature of the dispute, the documents available with both parties, the relationship between them. This is one step which will give you a good reputation among clients. There is nothing wrong in trying for a settlement at the notice and reply notice stage, depending on the facts of the case. They may be only 5% of cases which you get, but all the same, you will be giving a good service to your client. Definitely, you will receive your fees because client will be very much uh, happy to pay you fees if you can settle the issue at the stage of notice and reply notice if there is scope. If there is scope, that is one thing. Suppose, let us say it's a marital dispute. You take it to the district legal service authority, or you ask parties to uh, get their own persons to mediate between both of them instead of going to the court. So this will result in uh, good reputation for you, and it will also solve the problem between parties at an early date. So this is one of the uh, tips I want to give you. You should uh, look at the facts and see if you can solve the case through alternate dispute resolution. So that is one aspect. Now, there may be certain small issues between your client, say the MRO or the district collector or some municipality. Municipality is not affecting mutation. All these aspects, you can approach the district legal service authority if you are in headquarters, or Mandal Legal Service Committee if you are in Mofsal area, and you can file a pre-litigation case for simple things. And a notice is issued when the concerned official comes. The chairman of the Lok Adalat will definitely try to solve that issue. Please remember that pre-litigation case is one of the options in such matters, and it is also an option with regard to marital disputes. So these are some of the preliminary steps which you take as an advocate. Now we come to the stage where you have to file a suit. As I told you, you have to be conversant with the limitation for that suit. You have to write down the cause of action. Now, cause of action is a bundle of facts. Cause of action for the suit arose when the defendant executed a pro note on so and so date, agreeing to repay the amount as and when demanded, and the plaintiff made the moral demands, but defendant did not pay. All these uh, brief facts of the case come into the cause of action in, and also indicating the limitation period as well as the place where cause of action has arisen. That is when you again go to the CPC and verify where you have to file the suit depending on the transaction between the parties. and you have to decide on the relief. Is it necessary to seek declaration of title? Is it necessary to seek only injunction, permanent injunction? Is your party really in possession? Is it necessary to take ask for relief of possession also? If so, whether mean profits have to be asked as a relief? Please go through Order 20 CPC, where on what lines the court will pass a decree in specific matters is given. So that will give you an idea as to in what type of suit you have to ask for what type of reliefs. Basically, so 3 or 4 types of suits are mentioned therein. Now, this is what relief has to be asked is to be decided on the basis of the facts. Suppose there is constant interference from the defendants, whether by putting forth a weak title or something, then you may have to go for a declaration of title once for all. And please remember under section 34 of specific relief act, if you can seek a consequential relief and you don't seek it, then the suit may be dismissed. Most of the time, a relief of declaration regarding a title to property or status or whatever it is will be followed by a consequential relief. Therefore, what relief has to be asked is one aspect. And if you are seeking any rents or profits that have accrued by the date of filing of the suit, then you can ask them for 3 years prior to the filing of the suit, and then make a prayer that subsequent profits or rents shall be uh, part of the suit claim. And then please note, such other reliefs is one phrase which is used while seeking relief in a civil suit. I hope all of you are aware of this. Such other relief as the court may deem fit and proper. On this aspect, please go through Order 7, Rule 7 CPC. Order 7, Rule 7 CPC. Mr. Fanikumar,
Yes,
or
sir.
Sridev Garu,
Yes, sir. Yes, sir.
please read out Order 7, Rule 7 CPC.
Yes, sir. Yes, sir. Order 7 rule ఏమన్నా చెప్తారు సార్?
Rule 7, Order 7, Rule 7.
Yes, sir. 1 minute, sir.
Please read out.
Yes, sir. 1 minute, sir. But A relief to be specifically stated.
Hmm.
Every plaint shall start
State.
state specifically the relief which the plaintiff claims, either simply or in alternative, or it
And
shall
it shall not be necessary.
to ask for general or other relief, which may always be given as the court may think, just to the same extent as if it has been asked for, and for the same rule shall apply to any relief claimed by the defendant in his written statement.
So you see, relief to be specifically stated, but at the time, whatever can be granted by the court will also be granted. There is very good case law under this Order 7, Rule 7 CPC. You please verify that either in the AER commentary or any other commentary. You will get certain judgments which will enable you to seek a relief at the time of arguments, basing on what the defendant had stated or basing on what uh, is admitted by the defendant in the written statement or brought out in the during the trial of the case. Now, apart from the judgments which you are showing on the screen, there is a judgment of the Supreme Court in sometime in 1953 or 1957. Please go through that judgment also. Page number 171 or so, 1953 Supreme Court. So this is one um, provision which you should be aware of while you are framing the relief. So uh, please keep this in mind. And then what documents have to be filed along with this suit? Whatever documents you are relying upon, CPC says that you have to file all the documents that are available with you. And if the documents, some documents are not in your possession, you may also state that these are the documents which are to be subsequently produced before the court. And in case you think that a document, original of the document is to be preserved separately, you can make a request to the court that the document be preserved by putting it a sealed cover. So, and then you have to be aware of the court fee that is attracted to the facts of the case. It is ad valorem, that is simply basing on the table in this in the Court Fees Act, where you find from 10,000 to 20,000 and all that, and you pay the court fee. And while filing the suit, you should pay the process fee also to all the defendants. And if you are not able to pay the court fee fully on the date of filing of the suit, you have to file a petition for extension of time, and within that time you have to pay the court fees. If it is a title suit, if it is only for injunction, then you can put a fixed amount on which you are going to pay court fee. When I practiced in 1983-84, injunction suit was regularly valued at 300, but subsequently the court fee that is being uh, directed by the court has been increasing. So two aspects: the court can either accept your valuation or give its own valuation, and you have to pay court fee. If there is a denial of title in the plaint relating to this injunction, then you have to pay court fee on half of the market value. So these are all certain things which you should be aware with regard to jurisdiction, pecuniary, and territorial. If you want, we will deal with those issues separately as to how to decide the pecuniary jurisdiction and territorial jurisdiction in one class. So this is one thing. Then after the written statement is filed, if the party contests or some of the parties contest and written statement is filed, please note the written statement may put forth certain facts which you want to controvert by way of rejoinder. CPC does not provide for rejoinder, but in some issues, decisions have been rendered by higher courts that rejoinder is necessary. For example, as I told you, if the defendant comes forward with a plea that there is a will with regard to the property on which he is relying on, and according to your party, the will is not genuine or it was not executed in a fit state of mind by the testator, then you have to file a rejoinder. So with regard to rejoinder also, it is a practice which is required depending on the facts of the case. And then you have to look at the issues. Before issues, you can see whether any documents have to be sought to be produced by the other side. If the other side mentions certain document and does not file it, then you may issue a notice to produce the document. The court has to conduct examination under Order 10 CPC. You have to prepare your party for answering the questions under Order 10 CPC. And after all these steps are over, issues will be framed. What is the role of the advocate when the court frames issues? If you think that part of the suit claim is admitted by the defendant, or he has admitted the execution of the document but stated that the document was executed in a different set of circumstances and though not valid, depending on the facts of the case, the burden will be either on the plaintiff or on the defendant, and therefore, if you are appearing for the plaintiff, you should be cautious and you should be alert whether the plea taken by the defendant puts the burden on him to prove the case, and therefore, while framing issues, it should be framed placing the burden on the defendant. Just 1 minute, please pause for 1 minute.
నాగమణి గారు ఎక్కడున్నారు? Anvesh, you please just unmute yourself and see that no other voice come from your side. మీరు అన్మ్యూట్ లోనే ఉండండి.
ఓకే మేడం.
ఇంకా మేడం ఎవరో నేను కూడా అసిస్ట్ చేస్తా అన్నారు, కంది నాగమణి. మీరు ఒకసారి హ్యాండ్ రైజ్ చేస్తే మిమ్మల్ని నేను అన్మ్యూట్ చేస్తాను.
మేడం కో-హోస్ట్ యాక్సెస్ ఉంటే ఎవరినైనా అన్మ్యూట్ చేసే అవకాశం ఉంటుంది మేడం. సారీ, మ్యూట్ చేసే అవకాశం.
అవును, ఫణి ఇస్ దేర్.
ఓకే మేడం.
ఫణి గారు అయ్యారు.
So,
I just mute
With regard
myself
to
because
issues, the
someone.
burden should be properly indicated in the issues, and you are entitled to file draft issues for the benefit of the
అన్న
court, and you better be present while issues are framed.
బెటర్ అది మైక్ ఆన్ లో ఉంది మీ వాయిస్ కరెక్ట్.
So therefore, you can make a request to the court at the stage of issues that we will file draft issues, and we will also assist the court in framing the issues on proper lines, so that burden will be properly indicated and who has to begin the suit. All these things will come out in the issues. And you please remember that order 13 comes into is prior to framing of issues, and if you want to file any documents also, you can file those documents. With regard to any document which is liable to be impounded, suppose your opponent has filed a document which is liable for stamp duty and penalty, then you please look at order 13 rule 8 CPC. You can immediately ask the court that the document be placed with the superintendent of the court, and after impounding only it shall be brought again into the record. Please go through order 13 rule 8 CPC. It is very much clear. Now after this, these issues are framed, there is the practice of filing chief affidavit which is a replica of the plaintiff. That may not be correct. So prepare the chief affidavit basing on the facts of the case and what is raised by the defendant, and what part of the plea raised by the defendant has to be denied in your chief affidavit. You also indicate what documents have to be marked through the witness. It is better if you mention the document in the margin. Suppose you are writing a para with regard to the execution of the pro note, then in the margin you indicate that just exhibit A1, so that it will be of help to the court. And then you have to prepare your party for cross-examination. And we have seen how re-examination arises when we have dealt with the evidence act. Please note down any fact which is to be again asked in re-examination depending on what is elicited in the cross-examination. Therefore, and then you also decide how many witnesses have to be examined, for what purpose, who are they, to what extent they know the facts, whether they will withstand the cross-examination. Sometimes party may simply bring somebody stating that this fellow will speak about that, but you have to be sure that this witness will withstand the cross-examination by the other side, and he actually knows the facts, and whether he is worldly wise, whether he is alert in answering questions. Please remember that among the so-called illiterates, there are number of persons who can give very good evidence on any aspect. The only thing is you have to just verify before you put them as a witness. And then if you think that you need to adduce rebuttal evidence, there is provision in the rebuttal evidence in the CPC, I think order 18, and you reserve a right filing a memo that you are reserving your right for rebuttal evidence and so on so aspect, and the court will pass orders. And with regard to order of examination of witnesses, party has to be examined as a witness first and then others. And if for some reason you are examining the witness first and party later, then you have to take permission of the court. And if it is general power of attorney, you should be careful that the general power of attorney is able to speak to the facts of the case, and he should also know how he came into knowledge of those facts. Simply because there is something mentioned in the plaint or in the document, if he speaks, that is not sufficient. He has to know these facts, and he should speak to them. You please go through the case law with regard to the extent to which the evidence of a general power of attorney agent can be relied upon. There is case law. Previously, I told one aspect. In a case under 138 NI Act, it is not for the GPA to say that with regard to the resources for the loan advance or something like that. Therefore, all facts cannot be proved only through GPA unless the GPA is very much conversant with all the facts related to the party and has been in the know of things from the beginning. So this is one aspect which you should bear in mind. And then when the defendant lets in examination, lets in his evidence, then you should be prepared for cross-examination. Now, with regard to cross-examination, you have to deny certain things which are against the interests of your client, which are against the case of your client. You cannot leave them out without cross-examining. You have to cross-examine, you have to give suggestions. Therefore, pleadings also, you should be very careful. You should specifically deny whatever is to be denied. Otherwise, they will be deemed as admitted facts. So this is during the trial. And then it is better if you are aware of the legal position when you are conducting a case. It will help you in having a proper perspective of conducting the entire case. If a particular case law governs the parties, then you should bear in mind that case law and conduct the case slowly driving the facts to suit that case law. And then on this aspect, I have told you this Rahul Shah judgment, while speaking on execution petitions, that contains certain directions which are required to be followed during the conduct of the trial, so that there will be no difficulty in executing decree, particularly in suits relating to immovable property. Of late, I have been receiving calls from advocates known to me. Sir, the sale deed in favor of so and so is in so and so survey number, but he is building his house in our survey number or in our subdivision, taking advantage of our absence and all. So in all these aspects, you should try to follow the judgment in Rahul Shah's case. And another case which you should know is Maria Margarita, which is followed in Shanmugam's case in the year 2012. That also I have spoken to previously. And I think some of you are having the citation. That is, both judgments you can simply find out in the Google. Shanmugam versus Arya Vaisya, etc. Judgment of Supreme Court rendered in 2012, you will get it. Maria Margarita also you will get. And you please go through these two judgments because they give you a lot of insight into as to what should be done while conducting a case and how to convince the court, what the court will look to while deciding the case and all these aspects. So this is These are the two judgments. And another judgment rendered by the Supreme Court is that with a partition suit, the passing of the final decree need not be postponed, and it should be a continuation of the decree for preliminary uh, partition. So therefore, once shares are declared, there should be a continuation of the preliminary decree culminating in a final decree. If, for example, final decree is also passed, then subsequently, if there is necessity for filing another final decree petition, it can be filed. There can be more than one final decree, and there is also no limitation for filing a final decree. All the same, now the Supreme Court's direction is that the case should not be closed at the stage of passing preliminary decree, and final decree proceedings should follow. So this is the manner in which a civil suit is conducted. First thing is limitation. Second thing is territorial jurisdiction. Third is pecuniary jurisdiction. Fourth is a verification of any other special law which may take away the jurisdiction of the court. Because in such a case, if the court inherently lacks jurisdiction, it will be a void decree. Therefore, that should also be verified. Then what is the substantive law applicable to the facts of the case? And what are the presumptions that may be available to the party while conducting the case? And more importantly, what type of evidence is to be adduced to prove a certain fact? That is what I have stressed while speaking on Evidence Act. You have got several types of evidences which relate to several peculiar types of suits, say suits on account of something, custom or right. All these aspects are dealt with in the Evidence Act. More and more familiarity with the Evidence Act will give you a lot of insight as to how you prove a particular fact at a court of law basing on the evidence that is adduced by you. And you should also be aware of various types of public registers that will be available with the government. Not only Patadar passbooks, 1B, etc. I told you that there may be registers that are maintained by the irrigation department. There are registers that are maintained by other departments with regard to the activities carried on by them. Then entries in public records, they are relevant under section 35. And then public documents, and what presumptions are there, how to prove a document, all these things you have to lay out a plan and go accordingly. So these are some of the preliminary aspects. And another thing, during the course of the trial also, you may come across a stage where there is scope for compromise. As a judge, I have done this. I used to keenly observe the course of the trial, and after a stage, if I think that it is a fit case for compromise, I will suggest to the advocates. There were instances where the advocates completely left it to me to negotiate with the parties. They were not at all they are not at all present during the mediation, during my efforts to settle the matter. I did settle them also. And there is a clear provision in CPC that in all family matters relating to partition, maintenance, etc., the court has a duty to try for compromise. So, keeping in view all these aspects, I request you to prepare the case on sound lines, look for case law, and I am requesting each one of you to make your own effort to go through the commentary of a book if required, to read certain judgments while preparing the case. If you try to conduct the case on your own to the best of your ability and then go to a senior, that is a different thing. But if you go on relying on a senior or relying on the bench clerk for getting a matter registered or suit numbered, then ultimately you will not benefit. If you file one money suit on your own, you will be knowing the Stamp Act, you will be knowing the Limitation Act, you will be knowing the territorial jurisdiction, you will be knowing the pecuniary jurisdiction, and you will be, if you are filing a petition a petition for attachment before judgment, what affidavit should be there? What affidavit should be there in a petition for attachment before judgment? If you look at the case law, then you will know on what grounds attachment has not been given by the higher courts, on what grounds attachment has been refused, all these things. So therefore, try to prepare a suit by yourself. There are certain formats appended to CPC. If you are working in the office of a senior, you please note down on what set of facts reliefs are being asked, what type of reliefs are being asked. So therefore, these are all certain things which you should learn. When you are filing a civil suit, you should know the Limitation Act, Court Fees Act, territorial jurisdiction under CPC, pecuniary jurisdiction under Civil Courts Act, Stamp Act, Registration Act. Then if it relates to a partnership firm, Partnership Act, Hindu Succession Act, Specific Relief Act, Transfer of Property Act, all these have to be borne in mind. The relevant sections attracted to the facts of the case, and finally the Evidence Act, which gives you an idea as to how to prove a fact, how to prove a document, and all these things. And among the substantive laws, Contract Act is also there, Hindu Adoption and Maintenance Act, Hindu Marriage Act, Guardians and Wards Act, Hindu Minority and Guardianship Act. So you please, and you should read a journal. One journal you choose and read it thoroughly. Several types of issues will come up in those judgments. The Bare Act will be referred, the connected provisions will be referred, on what facts the case is upheld or dismissed, all these things, there is no option. Don't rely too much on the judgments available in the net. Please read at least one journal. It may be ALT or it may be AIR. Then after reading the journal, if you are still not satisfied with the case law you are having, you browse and get the answer for the latest judgments. So for today, these are some of the tips I want to give you. I don't know what time it is, madam. I have
It is 7:50, sir.
7:50. Okay. So these are some of the tips, and I would like to speak to you on pro note suits tomorrow. What issues will arise? What books are standard books? Because I think that is also one of the issues which some advocates are asking. What book is uh, what book is standard on a particular aspect? For example, on law of pro notes by G.S. Gupta, it will give you a lot of information about what issues will arise: acknowledgement, part payment, and then any unauthorized corrections in the pro note, death of the plaintiff, succession certificate, death of the defendant filing a insolvency case. All these matters are dealt with methodically in that book by way of different chapters. You can rely on this book with regard to filing suits for pronote. Law of Pronotes by G.S. Gupta. Recently, I have purchased it so that I can give you a comprehensive class for all of you on that subject. And then Specific Relief Act, you can rely on the book by G.C.V. Subbarao Garu. Civil Procedure Code, already I told you, Takwani. Evidence Act, though costly, Sarkar Evidence Act is recommended. If not, you go for Ratan Lal and Dheeraj Lal. I have recently purchased Ratan Lal and Dheeraj Lal. It is a very condensed commentary now. I did not derive much satisfaction from looking at the commentary. So better go for Sarkar Evidence Act. And then CRPC, you better go for that SP Tyagi book on criminal cases, criminal trial. SP Tyagi. Contract Act, again you have got good authors. Please verify in the Eastern Book Company publications. I'll also give you one or two standard books on Contract Act, and then Transfer of Property Act also dealt with by G.C.V. Subbarao Garu. And the Hindu law, you all know Mullah's Hindu law. So you have all these books. Court Fees Act, ALT publication. Lim Test Act, Mayanar Garu was saying about Mitra's book. Please purchase that. Develop familiarity with the books. Develop familiarity with the index that is there at the end of the book. Develop familiarity with related provisions. Develop familiarity with the order of provisions. So these are some of the tips. Because I am in Chennai today, I am closing the class. Any necessity for interaction, you may go on. Sridevi Garu.
Yes, sir. Yes, sir. I'm unmuting them, sir. So your this class is under live streaming, and you please ask
Hello.
the questions.
Sir, one doubt.
Yes.
Sir, a will is executed in which ancestral property and self-acquired property are distributed. Is it a
Yes.
valid will?
Mary, first you said release.
No, it is a will in which self-acquired and ancestral properties are distributed.
Yes.
Then the ancestral property cannot be written in a will because everybody has a proper right
Sir,
in the ancestral.
without who said it is ancestral property? Is it an admitted fact?
It is admitted fact that it is an ancestral property,
Yes.
and self-acquired property is also included in the same will.
Yes.
Then is that will is valid or invalid?
మొత్తం చూడాలండి. We have to go through the contents of the entire will. We have to see the pleadings, and then we have to see whether the will has been acted upon. What is the on such questions relating to facts, this is not the forum to give an opinion without looking at the documents. Kindly excuse me.
Okay, sir. Thank you, sir.
Only on what I have said today. If you think that any interaction is needed, please start the interaction. Otherwise, I will close I am not going to answer any question with regard to the case which is being dealt with by you.
Sir, good morning, sir. This is Jaikar here, sir.
Yes, yes.
It is presumed that a petition or every suit shall be instituted accordingly of a plaint. So, but this is not a question, but a guiding factor which any facts are missed out in an affidavit. So, I just want to state for the benefit of all, sir. You could have mentioned, but you presumed it because all might be seniors in filing plaints with accompanying affidavits. But I want to read for everybody's benefit. Every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed.
Yes.
In every plaint, facts shall be proved by an affidavit, provided that such an affidavit shall be in the form and manner as prescribed under Order 6 of Rule 15A. Just
Yes.
for everybody's understanding and guidelines.
Yes. These are all what you follow, but what I have spoken to you is the approach to taking instructions, preparing the case, filing it, and then conducting the case.
Sir.
You have to follow the procedure, whatever is laid down, you have to file an affidavit and all that. Along with the plaint, now you have to file an affidavit. You have to give a proper address also.
Address for service.
Address for service of your own plaintiff and also address for defendants. You should not suppress anything in the plaint.
Sir, suppression of facts, how do we dig out and how do we elicit is a meaning in a cross-examination. It's a court craft which pulls out, but any out of your experience as an adjudication and deciding officer, you can throw some light, sir.
No, suppression of facts is a case law. If you suppress facts, you may not be entitled to certain equitable reliefs under specific relief act.
Yes, sir.
Definitely it will be a disadvantage as per law.
People come with people will come without clean hands, sir. So, but at the same time, meaning it is the advocate or the defendant's counsel or the plaintiff's counsel who has to be wise enough to discover the gap.
So depending on the facts of the case, you can prepare, no doubt. But if you go on reading certain standard judgments, you will know what deficiency on the part of one party has caused loss to him, or ultimately lose the suit. So these are all aspects which you will develop by reading several judgments. Say agreement of sale, specific performance act, all these you will know when you read certain judgments. Why the suit is decreed, why the suit is not decreed, why only alternate relief is given, all these facts. So you have to cultivate. Even if you don't need a particular judgment, if you think that it has consider several aspects, and if it is a division bench or full bench judgment on a particular issue, then you read it. It may be of use to you sometime later.
Yes, sir.
Sir,
Thank
Madam
you, sir.
Garu? Thank you. Madam Garu?
Yes, I'm
Sriya,
there. Yes, sir.
today I'm closing.
Yes, sir.
Tomorrow
Thank
I'll
you.
speak to you. Okay.
Yes, sir.